2024, an election year like no other. From the candidates to the issues, from voter integrity and analysis, we'll discuss debates, trends, patterns, election laws, and more. This is Vote 2024, Path to the Polls.
The Supreme Court's immunity decision may have surprising consequences and reverberate on things other than the powers of the presidency. It may have an impact on Donald Trump's criminal cases. The court ruled presidents are immune from prosecution for their official acts. It has already prompted the postponement of sentencing in the business fraud case. That was supposed to happen Thursday. It's been rescheduled for September at the earliest. The ruling also has an immediate impact on the federal election case in Washington. It threw a proverbial monkey wrench in the bid to put Trump on trial for what the special counsel calls a criminal conspiracy to overturn President Biden's victory. What happens in the Georgia case remains to be seen. Judge Scott McAfee hasn't ruled in that election interference case yet, but the former president has made it clear he should not be prosecuted in that case either because he was acting as president. So the question becomes, does the high court's ruling play a role in Judge McAfee's decision-making? And of course, there's the classified documents case here in Florida. Mr. Trump's accused of slashing and stashing classified documents at Mar-a-Lago. Again, Trump's claims, you can't come after me because of immunity. The U.S. District Judge in that case, Eileen Cannon, may have to consider what impact, limited as it may be, the Supreme Court ruling has in the outcome of her ruling on Trump's motion. If nothing else, there is plenty of room for delays and litigation on those issues on the horizon. Welcome to Pass to the Polls. I'm Bruce Hamilton, and joining me is Jeremy Rosenthal, an accomplished trial lawyer who knows how to put cases together and tear them apart. He was a prosecutor before becoming a defense attorney. Hey, thanks for joining us again, Jeremy.
Good morning, Bruce.
Good morning. Supreme Court Chief Justice John Roberts wrote in the majority opinion that the president is subject to criminal prosecution for unofficial acts like everyone else. In a scathing dissent, Justice Sonia Sotomayor wrote, the court gave Trump all the immunity he asked for and more, and that the ruling makes presidents king above the law. One thing is clear. Trump is claiming the ruling is a victory for him, using it to his advantage. Did the Supreme Court hand him a new shield?
They handed him a lot. This is definitely a victory, if not for any other reason than it's going to hand him a lot of abilities to litigate and a lot of abilities to delay this. And to a certain degree, they did cut out a little bit of some of the prosecution at a minimum in the January 6th case. But it's not, I don't think, as sweeping as he quite makes it out to be. I think the vast majority of the victory here for Mr. Trump is strategic, is litigation oriented. I think going forward, I think everybody is concerned about the presidency in the future, in the next 10, 20, 30, 50 years. And how will we interpret this? And will it embolden a president to try to commit crime in office and say, well, you can't do anything about it because these are going to be official acts. And these ground rules that the Supreme Court has laid out themselves are going to have to be tested. So we can read what they say and we can kick around what we think they mean. But ultimately, we're going to have to test them again, potentially, to really have any firm understanding of where the boundaries are. This is still a very subjective opinion in many ways.
Concerning the criminal cases against Donald Trump, let's take this case by case. The business fraud case. The Manhattan DA, Alvin Bragg, he agreed to delay the sentencing, and it should be delayed until at least September, he said. Judge Juan Merchan agreed, set it for September 18th. But the DA and Trump's lawyers disagree on some salient points here. Trump's attorneys argue the court's ruling confirms their position that Alvin Bragg should not have been allowed to offer evidence at trial regarding what they say were official acts. And as a result, Trump's guilty verdict, they say, should be set aside. The DA's office says the Trump arguments are without merit. Your thoughts?
So we're getting really, really into the nitty gritty of the Trump opinion, of the immunity opinion. So let's kind of clear the table and let's just put on our lawyer hat here for a minute and kind of think about this. So the first question we have to answer is, what are we talking about as far as an official act versus an unofficial act? Well, the entire scheme, as alleged by the New York District Attorney's Office, Alvin Bragg, is that Donald Trump, before office, paid Stormy Daniels all of this money to keep these things secret. Obviously, there's not going to be any immunity there. Once in the White House, the question is, are Donald Trump's acts immune, or are they official or not official? And so let's remember, we kind of got to get into the weeds here for a minute, okay? Because part of the trial, there was testimony that Michael Cohen talked with Donald Trump while Donald Trump was the president, that he was in the Oval Office, and Donald Trump was talking to him about his reimbursement, that Hope Hicks, while working for the White House, was having conversations with Donald Trump about the Stormy Daniels issue, that Donald Trump was tweeting things, saying things publicly while president when this whole thing was breaking. And so the question is, first off, are those going to be official acts or unofficial acts? Obviously, I think we're all going to agree that those are all unofficial acts. However, the Supreme Court, in the majority opinion, said that some of the content is off limits when it comes to the presidency and if he is exercising those acts. So it could be that there are some issues in the that were raised during the trial that could, I guess you could say, for lack of a better word, have infected the overall case. Judge Merchan, what he is going to do is he's ordered Donald Trump's lawyers, look, you guys brief these things out to me. You tell me, you guys, Donald Trump, you and your lawyers, you read the opinion, you tell me where it hurts. Okay, you tell me where the U.S. Supreme Court says that this conviction is no good, and I'll listen, as he should. He still has time to fix this before it goes on appeal. So Trump and his team are going to try to point out those certain areas where Donald Trump did act as president, whether it was a conversation or not. Then the court's going to go through that analysis. Okay, official act or unofficial act. If it is not an official act, then the courts kind of start parsing through some of that immunity. And then if it turns out that Judge Merchan says, okay, some of these things were in fact off limits, then the judge has to do what's called a harm analysis, which is the judge saying, okay, did this actually affect the overall verdict? I know it's really complicated and it's pretty in the weeds, but that's basically where they are. Essentially, Judge Merchan is measuring twice and cutting once, as he should. I think at best, and I don't see this happening, I think the conviction is going to stand, and I think Judge Merchan's going to say, okay, thank you, Mr. Trump and your lawyers. I've heard your arguments. I don't think that this impacts the jury's verdict. I think that's what happens. If he agrees with Trump and his lawyers, I think he may set this thing for a new trial. I think that is the best case scenario for Mr. Trump in those cases. I do not see this conviction just getting thrown out and the state's case getting dismissed. I don't see that happening at all.
But you don't think he's going to get sentenced on the 34 felony counts as they stand now?
I think he may very well. I think the judge is going to try to hammer through some of these issues first. Again, as he should. I mean, the U.S. Supreme Court just weighed in on the thing. And the question is, did the Supreme Court target this at the New York case too? Because I think you can really make the argument that they potentially did. And Justice Amy Coney Barrett, in her, she agreed with most of the opinion, but disagreed on a little chunk of it. And the little chunk of it she disagreed was with this exact part. Why are we going to make all these new rules? So, and let me kind of back up here, Bruce. Do I have permission to nerd out here for a minute?
Oh, sure.
I've kind of been doing it. Okay. So we've got the three categories that the Supreme Court has talked about here. Official acts. Think the ability to pardon. Think being commander in chief. There are parts of the Constitution that say the president shall, the president may, the president can. So the Constitution gave the executive certain powers, and in those areas, he is completely immune. Then we have presumptive official acts where there's presumptive immunity. Think President Biden at the G7 summit this week. He's talking, he's shaking hands, he's making informal deals. It's not in the Constitution that he can do this, but we all get it, right? That's what the president does. Think of the president of the United States. Think of President Carter brokering a peace deal between Egypt and Israel. Constitution doesn't make that his job, but it is presumptively presidential, right? We're going to give him that latitude. And if you want to prosecute him for something out of that, then you're going to have to show that's where it's bad. And then there's writing checks to Stormy Daniels or Michael Cohen, whether he is paying Michael Cohen hush money, whether he is paying Michael Cohen to mow the lawn. Those are all unofficial acts. Nobody elected the president to do any of that, so there's no immunity there. So we start from that framework. But, and this is kind of the nerd out part, let's think of it like this. They also set a handful of extra rules that I think that, and that's where Justice Coney Barrett said, no, now you guys have gone too far. And I think that Justice Sotomayor in her dissent was pointing at these, right? So let's talk about, can we pay the president $5 million in exchange for a pardon? He has the right to pardon whoever he wants. That's why the president has been elected. Constitution says it. But he has got absolute immunity for that. And the Supreme Court says, well, you can't talk about the intent here. You have to just look at the act in and of itself. And Justice Barrett said, well, hold on here. Why are we going to go that far, right? Why are we going to sort of rewrite these rules? And also, the court said, even if it's not the criminal act, just the things that he does as president are off limit at a trial. Think about New York State, right? Talking to Michael Cohen in the Oval Office. In essence, was the Supreme Court saying, you guys shouldn't have brought this up in your trial in New York? I don't know. And that's what Judge Merchan is going to decide, because it kind of seems like the court was really potentially reaching that far in their opinion. Done nerding out.
See, I think it's interesting that you bring up Amy Coney Barrett, because when we button this thing up, I think something that she said is the key to all of this. And when we wrap this edition of Path to the Polls up, I think you'll see what I mean. So let me go back to this. We mentioned the court's ruling may have a ripple effect on the other cases. So let's take the three others one by one. The federal election interference case brought by special counsel Jack Smith. Trump's been charged with 4 crimes in this investigation. 2 relate to the disruption of Congress certification of the electoral vote on January 6th. 1 alleges a scheme to defraud the United States through a sustained effort to impede the collection, counting, and certification of votes in that 2020 election. And the 4th charge accuses Trump of a conspiracy to deprive citizens of a right secured under federal law, specifically the right to vote and to have one's vote counted. So the status of this: an initial trial date set for March 4th, 2024 was called off after Trump's efforts to be declared immune from charges related to his conduct as president stalled pretrial proceedings. Now that the court's issued its ruling on immunity and sent the case back to the lower courts, it is unknown when that trial is going to be held, but certainly not before the election November 5th. So the quandary for Judge Chutkan here is to determine what counts can stand and what can't.
That's exactly right. And you have another opinion that the Supreme Court ruled on earlier in the week, which talks about the conspiracy, the conspiracy on January the 6th. That law, which was in that case was a 6-3 opinion, but in that instance, I think Justice Barrett actually sided with the 3, and Justice Ketanji Brown Jackson, she sided with the majority on this, and what they said was, look, this conspiracy law was made to keep people at Enron from shredding all the documents, to disrupt an official proceeding. So it has to be disruption by way of essentially documents or things like that. Does Jack Smith go back to the table? Does he say, okay, well, this fake elector scheme was the disruption that qualifies? He may feel good about that. He may not. But you're absolutely right. Judge Chutkan, what she's going to have to do is she is going to have to go line by line through this indictment, and she is going to have to balance the Supreme Court's mandates, which say, okay, what are official acts, what are unofficial acts, and which are presumptively official, and has the government overcome those? And it's going to have to be a very detailed line-by-line analysis. That may very well be before the election. That also may be very public. I'm not saying Mike Pence is going to be on the witness stand at some point in September or October, but that's what we may see. So we may not see a trial, but we may very well see some of these witnesses who have testified at the grand jury, who so far we don't know exactly who they are or what they've said. We may see those things. So in essence, while Donald Trump may want to avoid these things being aired publicly before the election, they may lose this battle. We may have a very public hearing where all of this dirty laundry is aired, with Judge Chutkan basically saying, okay, this is immune, this is not immune. And then, obviously, assuming that some part of this indictment survives, if Donald Trump is convicted at any point, it's going to go back up to the Supreme Court, and they're going to probably rearrange this whole thing.
Oh, and the former vice president's testimony would be eye-opening, to say the least. Now, I'm no legal expert here, but the judge's ability to inquire about Trump's motives was, I believe, limited by the justices. So that said, might the special counsel go back to a grand jury and do an end around and try and modify the case and get some sort of a superseding indictment here?
Bruce, you are completely wrong about this. You are an excellent lawyer, and you speak like one, and you're actually you're a step ahead of me. That, I think, is exactly what Jack Smith is going to do. Jack Smith got a roadmap here too, in the middle of this case. So what you have, in essence, is the Supreme Court also told Jack Smith, okay, here's how you get it right. And so Jack Smith, I do think it's very possible, if not probable, that now that part of his case has been gutted, that he has to rewire this thing in light of this new opinion. How he does that, I don't know. He may make it more focused on some of the things that are more clearly out of bounds, because I do think the Trump opinion did reference, look, this idea of fake electors, that's nowhere in the Constitution, Mr. President. That doesn't come under your abilities to, that's not your job as commander in chief. That's not your job necessarily as the chief executive. It doesn't fall under any of those things. So I think they may kind of end around it like you said. Another point to this, which is a lot of this puts a lot of these issues in the Oval Office on their head. In the New York case, the prosecutors there showed this man did these things, a lot of them in the Oval Office, for shame. And they used it and spiked the football. Had, in retrospect, they would have completely avoided anything in the Oval Office if they had known, obviously, after the fact, that could be an infection point that Trump could later point to. I mean, they didn't know what the Supreme Court was going to rule, so, I mean, how could they do that? But I think you're exactly right on this point with Jack Smith.
So then Judge Chutkan puts on her poker face and holds a series of hearings, and with an updated indictment carves out a new version of the case against Trump that meets the court's new standards.
Or so they think. Yes, that's right. I think that's exactly right. So, but the point too, and why ultimately this is a victory of sorts for Mr. Trump, is that this is all litigation, right? If you are defending somebody, your tactic is delay, delay, delay. Every day your client is not on trial, every day your client is not in handcuffs, is a victory. If your client happens to be has a big job interview the first week of November, and you can delay the whole thing until after that, then in some instances it's a limited success. But this is all going to be the subject of all these litigations. And yes, we're going to see a whole lot of chess from this point forward between Jack Smith, also between Mr. Trump's lawyers.
So if it plays out like this, do we assume there's some ambiguity in the case and there could ultimately be some airing of evidence in the judge's courtroom?
There may very well be. And I think Judge Chutkan knows that. And I think that Mr. Trump's lawyers know that. And I think Jack Smith knows that. So I wouldn't be surprised to see a kind of a bloodbath of a hearing before the election. So again, you may win part of the battle, but you might lose that part of the war. And obviously that has the very real possibility of influencing public opinion prior to the election.
All right, so let's move on to the election interference case being handled in Georgia State Court, one being prosecuted by Fani Willis. The indictment accused 19 named defendants of criminal wrongdoing, contained a total of 41 state law felony charges. 13 of those felonies were leveled against Trump. March 2024, Judge Scott McAfee threw out 6 of the charges, including 3 against the former president, because McAfee found that the allegations supporting the charges weren't detailed enough. But prosecutors can refile those charges with more details, and the most serious charge still stands, an alleged violation of the state's Racketeer Influenced and Corruption Organizations Act, commonly known as RICO is what people call it. That law allows prosecutors to package together disparate crimes if those crimes advance a single corrupt enterprise. The status of that court hearing right now. Georgia case is currently delayed as an appeals court considers Trump's challenge to Judge McAfee's decision not to disqualify Fani Willis, though experts suggested that Trump could likely use the immunity ruling to extend the delay if or when the case is remanded back to Judge McAfee. Now, this case here is shaped by the fact that it focuses on Trump's conduct while president. So the rule for absolute immunity may apply here, would it?
This thing is an absolute mess. Of all the cases right now, this is by far the most bogged down, stuck in the mud case of all of them. As you mentioned, we're not even talking about the immunity issue yet. We still have to fight through the disqualification motion, which is at an intermediate court of appeal who has 0 time frame, who we don't know the politics of that court of appeals relative to the Fulton County judiciary. So we just have no idea what's going to happen. When it does come back, we're absolutely going to have to do the same thing that Judge Chutkan is doing, which is the trial court in that case is going to have to conduct an analysis, what's official, what's not official. 100% of the acts, as alleged, were while Donald Trump was in the White House. So we're going to have to go through all of those things. It may be that some of them survive. It may be that it guts a good part of it. It does give Fani Willis and her team a roadmap similar to Jack Smith. This thing might not get to trial even in 2025. So this one is a long way off. And it is, again, this one's stuck in the mud big time.
But the thing that may unstick it, the bugaboo here, is that some legal analysts suggest the Georgia case's emphasis on conduct related to state officials, private individuals, could actually help prosecutors. And the reasoning, from what I understand, is those interactions are less likely to be considered official acts.
That's correct. Again, the judge is going to have to go through all that, right? Because remember, the Constitution, if it's enumerated in the Constitution, the president has absolute immunity. If it is one of those things, again, think the president helping a labor union solve a dispute with management, right? We're going to bring Teddy Roosevelt's going to bring everybody into the White House, and we're all going to sit there and he's going to stand on you until you've made a deal. Think about that. Think about President Biden at the G7 summit. President of the United States gets on the phone with a state official, and we can't really talk about the intent there, but we didn't elect the president of the United States to get involved with the state official, did we? So the judge is going to have to go through that analysis. But I believe that you're correct. Ultimately, I think the court will come back and say, that's not an official act. There's no immunity for you, Mr. Trump, getting on the phone with the Georgia Secretary of State, Brad Raffensperger, and threatening the guy, if that's what the evidence shows. So I think ultimately you are correct. The fact that he is dealing with these state officials is going to make it unofficial, but we still have to go through the legal process to get there.
All right, then there's the classified documents case in South Florida. When Path to the Polls continues, we take a look at efforts at that case that seem to be dragging on as well. And Justice Amy Coney Barrett's take on the immunity ruling, which specifically addresses Trump's fake elector scheme and may throw a wrench in many legal arguments. That and more when Path to the Polls continues after court takes a quick recess. Welcome back to Path to the Polls. Let's talk about the classified documents case here in Florida, Jeremy. The Espionage Act makes it a crime to retain records containing sensitive national security information. First 32 counts against Trump arise from 32 specific documents that he allegedly hoarded at Mar-a-Lago and refused to give back, even though he was no longer entitled to possess them after his presidency. Of the 32 documents, 31 were marked classified. Many concerned foreign military capabilities, military activities, or nuclear weapons. That's according to the indictment. The remaining 8 felony counts arise from Trump's alleged efforts to stymie the investigation, including directing Nauta to move boxes in the hope that neither Trump's own lawyer nor the FBI would discover some of the classified documents. Now, Trump's lawyers argued that the criminal charges stem directly from official acts by President Trump while in office because he allegedly designated the classified documents as personal records while he was president. Many legal analysts disagree. Their argument is it involves conduct after he left the Oval Office. Valid arguments here because there is no official action.
I don't know that the Trump opinion that just came out last week is going to help him here, really. I think if I was Trump's lawyers, I would argue the same thing. But I don't know that any of them are going to be any good. Really, if anything, that goes to his defense of these is that these were not classified. But the offense is committed when you are in possession of these things and you're not allowed to have them. And he just wasn't the president during really any of the relevant time. If there are allegations in the indictment that do stem from his days in the White House, that's an easy fix. You cut that stuff out. Maybe you go back to the grand jury. Maybe you just dismiss whatever language that is. But I think that part's a pretty quick fix. I think of all the cases, the new opinion affects this one the least.
Now, the judge hearing this case, Eileen Cannon, has been dragging her feet. And in fact, Saturday, she granted Donald Trump's request for even further briefings. And that means pushing back more deadlines. The court's ruling on immunity really legal cause for her to question things as she continues to do. And in fact, there are some who say that she's not legally qualified to hear this case. I mean, there's no trial date in sight here.
Well, it's a good thing that every judge I've ever been in front of in my whole life is qualified, because that would really suck, wouldn't it? If the judge didn't know what they were doing. She's a judge. She has been confirmed by the U.S. Senate, appointed by the President of the United States. It's her case. The 11th Circuit has had to slap her hand. In this case, it's very possible, if not probable, that they'll do it again. She can entertain all the arguments she wants about it. I don't think it's going to get them very far. She may never want to try this case. Who knows? She's a judge, and she's entitled to run her court as she sees fit. Jack Smith and his team, if they don't like her rulings, they're like any other litigant. They can appeal them up and hope for relief. But there's been some significant delay in this one, and there's no reason to think that that's not going to continue.
So, but basically what you're saying it is what it is. It may not matter that there may be politics at play, and I'll leave that at that. Mm-hmm. There is another issue here. The defense argument that the special counsel, Jack Smith, was illegally appointed as special counsel. Justice Clarence Thomas wrote that if there is no law establishing the office that the special counsel occupies, then he cannot proceed with this prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. Does that further muddy the waters in this case?
I think it will ultimately. I think if he's given a chance to rule directly on it, then potentially if he can bring some of the other Supreme Court justices with him, and really it kind of goes to the heart, if you will. And this is almost Watergate all over again, right? Because in Watergate, you had President Nixon in the Saturday Night Massacre firing one attorney general after another until they would go and fire the special prosecutor. So the question is does the special prosecutor themselves have to be appointed or approved by the U.S. Senate, which again kind of gets us into this whole separation of powers argument again. It does muddy the waters on it. And we'll see if ultimately there's a delay based on this as well. We'll see if this goes up to the Supreme Court. This could potentially very badly shatter the framework of how we have investigated presidents in the past. Because, and to kind of go back, and I promised I wouldn't nerd out and I'm like every other lawyer, and this promise is like every other promise that a lawyer makes. You just break the thing. Right. You had Bill Clinton investigated by Special Prosecutor Starr. You had President Nixon and Special Prosecutor Jaworski, Special Prosecutor Richardson. You have these things, and ultimately, the president is the head of the Justice Department. The Justice Department and the Attorney General are the executive branch. That's the presidency. So how do you prosecute a sitting president or a former president when the people at the very top don't want to be investigated? That is a separation of powers problem. So if Clarence Thomas is right, then you've got to get Congress to appoint that person. But then what you could have is you could have a party who is in charge who doesn't want to do that either. And it really frustrates and thwarts that. So does this mean that we're going to re-examine the framework where we reevaluate or we evaluate the executive? And if so, is there anybody that can really do that? Clarence Thomas may tell you, well, if you don't like the president, impeach him. And if the president does an official act that you don't like, if it is a high crime or misdemeanor, you can impeach him. There's no immunity from impeachment. So he may tell you that. Maybe it's a subterfuge to just get rid of Jack Smith because you don't like the guy. But we'll see where this goes. This issue may have more legs than I think some people are going to like.
You know, I don't think you're nerding out here. And the reason I say that is because I don't necessarily think it's just muddying the waters. I read an article in the New Republic, and the headline was, does this decimate Jack Smith's case? You know, so you have to ask, does it upend all his work? So no, you're not just nerding out here. I mean, it's a valid question, and it's one that's going to be asked and looked at. Now, if you're looking for a silver lining here for Smith, it may be that Judge Chutkan, as one analyst put it, now takes back over with a fact-specific analysis whether Trump's actions, this goes back to what we were talking about before, were official acts or not.
That's right. So yeah, Judge Chutkan. Look, I mean, and you've got Judge Cannon, who is making her decision on the situation. She is gonna, and that could get appealed up to the 11th Circuit by Mr. Trump, and then the 11th Circuit could agree with Judge Cannon or not, and then the U.S. Supreme Court could invalidate the framework. They could invalidate Jack Smith's appointment. Is what they could do, and now, and that could ultimately, by extension, unplug Judge Chutkan's case in Washington, D.C. It may be well after the fact, but it could do it. And in the interim, again, there could be a very public hearing about this immunity, and maybe those people who are, I guess, not to, the folks who want their pound of flesh out of Mr. Trump, that may be as good as they're going to get before the election. And ultimately, whether or not he is convicted of any of these things still remains to be seen. Again, notwithstanding the New York case and Judge Merchan, who we talked about a while ago, they're kind of in their sort of disinfectant role, if you will. Did we hear evidence that in retrospect violates the separation of powers, and if so, did it affect the overall outcome? So it remains to be seen. A lot of this is still in play, and there's just going to be a lot more of duking it out as we thought there would be. Right? I don't think anybody who looked at these cases, just going forward from the moment that they were indicted and brought, I don't think anybody thought that this was going to be easy. I don't think anybody thought that Mr. Trump and his team would take this laying down. Certainly the man's got a lot of resources to fight and litigate these things. And we're getting questions answered that we've never had asked before. That's how the courts work.
Look, I don't harbor any illusion that we're going to know anything before November 5th, but afterwards, regardless of who wins the White House, in the end, Could they prove something the former president isn't ready for or doesn't see coming?
Potentially, if that's going to happen. So right now, Judge Merchan in New York State, let's say that case does proceed to punishment. Judge Merchan has at his ability, so he has, and I'm in Texas. In Texas law, if you are sentenced to prison, if that prison sentence is below 10 years, you're statutorily entitled to an appellate bond. You can get out. You don't have that right in New York State. So Judge Merchan could lawfully tell Donald Trump, I am sentencing you to 20 years, go with the bailiff, and the bailiff can take him right there. Legally, that can happen. I think it's very unlikely for a lot of reasons, not the least of which is that 9 out of 10 people charged in Manhattan with this offense get probation. I mean, I don't think that happens, but legally something like that could happen. The option is there. It could be that Judge Merchan puts Donald Trump in jail for a short while based on the contempt, based on some of the things that happened during the trial. Things like that could happen. If there is a curveball left before the election, the two areas where I think you're going to see it are the January 6th. I think that Judge Chutkan can have a hearing that is gory, right? That's going to be where they're going to flesh out a whole lot of these immunity issues, and Judge Merchan's sentencing. So I think that those are the two areas. If we're going to get a curveball before November 5th, I think that's where it's going to be.
All right, let me go back to something I said I was going to do and put a bow on all of this, throw it back to the Supreme Court. Is Donald Trump celebrating a bit prematurely, which he did do on social media? And I ask that because Justice Amy Coney Barrett says presidential immunity does not apply to Trump's fake electors scheme. Specifically, Barrett agreed with liberal Justice Sonia Sotomayor's dissent that acts which take place while a president is in office should be allowed to be introduced as evidence in a criminal trial, writing specifically about Trump's fake electors scheme, quote, "In my view, that conduct is private and therefore not entitled to protection." How does that play in all of this, Jeremy Rosenthal?
It shows you how fragile this Supreme Court alliance is. You've got 6 conservative justices, and you've got one who's kind of sort of saying, well, hold on here. Let's not get too far away from this. And so if you are prosecuting Donald Trump and Judge Chutkan does rule that the fake elector scheme is not legal, or is not is not an official act, and then you got that wonky rule about what they can consider and not consider, and it goes back up to the Supreme Court. Does Justice Coney Barrett, is she able to pull one more vote away from that 6-3 majority? Because if she does, then you've cracked the code. Then you have prosecuted him successfully, and the Supreme Court at that point would be 5-4 in your favor if you are just kind of doing the math and counting the numbers. So it shows you just how they got their X-Acto knife out. And really, I mean, this is a very, very long opinion. These justices are all very smart. They are the best. They are the creme de la creme, if you will, of legal scholars and analysts and analysts. You can like them, you can hate them, you can agree with them, you can disagree with them, but they know what they're doing, and they're measuring twice, like I said, and cutting once. And Justice Barrett was very deliberate in the language that she used about that fake elector scheme. And again, and she also said, I don't know what we're doing here by making some of these other rules. I don't know why the rules of evidence can't handle this. I don't know why the jury can't hear that the president of the United States, in essence, had a conversation with the Justice Department that said, I want you to investigate this. The jury can decide that on their own. Why do we as the Supreme Court need to make a new rule to block that part of it out? So I do think that the alliance, the 6-3, the 6 justices, I think it's a little more fragile than people think.
Surprised at all that her writing was as specific as it was?
Well, I mean, she's earning her paycheck, isn't she? These people nerd out. What can I say? But again, it's just things that that the lawyers kind of key on, and it's really nuanced language. And if this opinion, and when you let's fast forward, let's look at Justice Sotomayor's dissent. She says you've made bribery legal now, right? Because the president is has the absolute constitutional, completely immune power of pardon. We just said that, right? Because it's in the Constitution, he can pardon whoever he wants. And if he takes a bribe, now you're telling us, Supreme Court, that you're telling us that we can't talk about the president's intent in a trial about this. That's what makes this, I think in Justice Sotomayor's opinion, that's what makes him the king. That's what gets them over the top. The Supreme, when they circulate these opinions, what they do is they kick these things back and forth, right? The dissent knows what the majority is writing, and the majority knows what the dissent is writing, and they go back and forth, and they go back and forth, and they have coffee, and they go Ruth Bader Ginsburg and Justice Scalia, they go whatever, horseback riding together, and then they have these disagreements. So they know where they know what the other one is doing and saying. So I have to think that they inserted some language, the majority did, Justice Roberts did in his majority opinion. And what he says is, if it is manifestly and palpably outside the scope, then you can prosecute it. Well, what does that mean, right? Does that mean that we just, the Supreme Court's definition of pornography is we can't really define it, but we know it when we see it. So is that what they're saying? That if we have SEAL Team 6 go and assassinate a political rival, that we can then hit that button and say, well, that is manifestly and palpably, 2 words that I use very rarely in my office. I use a lot more profanity. I've got a cuss jar over here to prove it. It's a lot more handy in a law practice than palpably and manifestly. But is that manifestly and palpably so outside the scope that we can now prosecute? That's the battle line here, right? And that's what Justice Coney Barrett really hit on. And again, she's that 5th, 6th vote. And so again, just to kind of talk about how fragile that is. And so if Donald Trump celebrates it, I think he does it at his peril.
But Jeremy, you know why I asked that question, because the integrity of the court is very much in question these days. You know, John Roberts, because of some of the things he said politically, Joseph Alito, because his wife was flying the flag upside down. So that's why I felt it incumbent to ask that question. It has been a fascinating discussion, went on a lot longer than I expected, but we had so much ground to cover, and there's so much more we could cover. You know, I'm sure we'll chat again. I do appreciate your time, your expertise, and the context, perspective, and focus that you've certainly delivered this morning.
Always, Bruce. It's always fun.
Jeremy Rosenthal, thanks. And for those of you that have watched an encore presentation of Path to the Polls tonight at 7 o'clock, you can watch on demand streaming on the News4Jax YouTube channel and news4jax.com. Appreciate you.
See why every day more people are choosing News4Jax, Northeast Florida and South Georgia's #1 source for local news.